Because it's a matter of secret state privilege, and it's also connected to the United Nations.
Mr. Evans.
Yes, ma'am. Are we?
I'm,
Hello, Your Honor. Are we on the record?
we are on the record. Thank you for asking.
Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on standby.
You don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
No, I'm
please.
not going to do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like, I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates,
Correct.
which will prolong my time in jail.
I don't know that.
Possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail. I'll do my best to work with this guy.
Okay.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for?
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send two different letters?
Yes.
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
You'll have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send one letter. In the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, can you tell the jail, give me sufficient paper so I can make 2 copies? Because they're not giving me what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati and then he can make copies for both the court and the city.
Okay, Mr. Ionati, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionati.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. McCoy Sr. He believes that they're all witnesses for these case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said, That's a matter of secret state privilege. I don't want you discussing that.
Okay,
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ionati if he's doing
Sir, you can't get restitution. I mean, I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal, there's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
No.
And not even my rights as a tribal chief.
You have asserted that you are a tribal chief. I have seen no evidence of that being true. Just because you say it doesn't make it true.
I gave you the proof, but you needed the physical case in front of you, which has a seal on it. So even if it's in front of you, you still won't be able to see that I'm a tribal chief based on having a case in front of you.
It's my understanding that Mr. Ionati was able to obtain that document.
Correct, which is a matter of secret state privilege.
So you can't say it's in this document and then not let me see it.
I'm just stating facts. That case is a matter of secret state privilege. So that would be grounds would that be grounds to get it transferred to federal court?
The issue is whether you trespassed at the airport, sir. That's the only issue.
I understand, but as a tribal chief, I have the right to have any grievances between me and the state heard before the United States Supreme Court due to me representing a sovereign state that's federally and internationally recognized, a sovereign tribe that's federally and internationally recognized.
You won't tell me the name of the tribe. You won't show me the document.
It's a matter of secret state privilege, Your Honor.
You can't have it both ways.
I'm just stating facts. It's a matter of secret state privilege.
So no, as I understand it, the city is not willing to transfer this case to federal court.
Mr. Ionati, I would like to appeal anything that's being declined. I just want to get this on the record that I want it appealed. Anything that's being declined, I want it appealed.
Sir, you represent yourself. It's up to you to appeal.
Okay, no problem. I'll send a letter out today with a notice of appeal to the Supreme Court of the state of Washington.
Appeals from courts of limited jurisdiction, which is what we are, go to Superior Court, not the Supreme Court.
But I'll try to speak to them based on the circumstances that I would like to oblige directly to the state Supreme Court due to the circumstances and the fact that it's connected to a matter of national and homeland security.
You're going to have to show them proof that that's the issue too. You can't just say a thing.
I will show them the proof. I will show them the proof with no problem. It's on them if they want to do their work and research and diligence to get the answers that they want, that they seek.
So,
I will show them the proof.
Once again, courts are not investigative bodies. They will do no research. They will not do an investigation. That is up to you.
I understand it. Exactly. And I'm doing an investigation on my behalf and I'm providing everything that they're asking me for. They just don't like my answers. I'll deal with that on the federal level when I file a notice to remove. Once I get out of jail, because I can't do. Also, if Mr. Ionetti, if you can file a notice to remove with the federal courts or with this court, I would like that as well, please.
Mr. Iannetti, do you have any concerns about Mr. Evans' ability to proceed?
I do. I mean, I don't have anything to verify any of the claims that he has made and the information and who he's asking for as far as witnesses in this case lead me to believe that there may be issues.
Do you think it's appropriate to have him evaluated under 1077?
I do.
Does the city have any objection to the ordering of that evaluation?
I have an objection.
Okay,
Can I object?
you can object.
Yes, ma'am. I assure you that I'm 100% competent, and I assure you that everything I'm saying is true. As far as civil case 24012 out of St. James Parish, Louisiana, that is a matter of secret state privilege, and it also verifies the facts that I'm making that you guys claim you cannot prove.
But you won't let us see it.
Mr. Ionetti has to get the case himself.
He has it.
So
have
tell
the
him give it tell him
What?
give it to you.
I
Tell
don't know.
Mr.
Can I identify the case, Mr. Evans?
Civil case 24012 out of St. James Parish, Louisiana.
Can I identify the case and the information that I have?
Like I said, you can give her civil case 24012 out of St. James Parish, Louisiana. If she wants to look over it, it has a seal on that case. So you're gonna have to get permission to get that seal removed.
So
to
it's my
get the
understanding
true contents.
it's my understanding it does not have a seal.
That's the information that I have is it does not have a seal. It's a 1996 case, Blue Harvest Maritime versus Opal Evans. It was a suit for damages.
That's the guise that it's under, but the true contents of that case is under seal, I assure you.
And Mr.
I
Evans,
guarantee it. I'm not
person
guessing.
who can take it out of seal.
I'm not guessing, I'm guaranteeing it, because I became the chief of a federally and internationally recognized tribe when my father passed in 1993, and everything was made official with that case in 96. I guarantee it.
So if it goes to me, it goes to the city as well. And are you okay with that?
I would like to have it sealed due to the fact that it's gonna expose innocent life.
It's a matter of
including my own.
public, sir, it's a matter of public record. And it's not filed under seal. That I don't know what the justification is for sealing it in this court.
That it's gonna affect innocent life, including the names that he named that I don't want named with public, to have public access to those names on that case and whatnot. It's definitely gonna affect innocent life, and it's connected to a matter of national and homeland security.
Mr.
I
Iannetti,
guarantee.
what you were able to, what you have in your possession is a matter of public record. Is that right?
The information I just have is what the court clerk told me. She indicated that I can pay $1 a page for the file. They weren't able to tell me how many pages were in the file. They said it was archived based on the age. It is, it is a state court. And they indicated it was a suit for damages, and not consistent.
It's connected to my estates that I have, plural. Is it all making sense now?
No.
And there's only, Mr. Evans indicated that there's something in the file that's only one person has the ability to unseal, which
And that's
is not
Chief
consistent
Justice
with,
Roberts.
and that's not consistent with the way the law works. So
I'm
that's
the
where my
rarity.
concern-
I'm the rarity in this case, I assure you.
That's where my concern is. And I mean, the amount of money that could be for the amount of documents in the file, I'd have to ask if the court wants me to try and make that request to get that. I can make that request. I would need funds from the court, and I don't know how much. But a state case that would be doing what Mr. Evans claims is not consistent with my understanding of the law. And the fact that a chief justice is the only one that could unseal something within that case is also not consistent with my understanding of how the law works.
Particularly if it's a state case, I don't see how Chief Justice Roberts would be involved at all. Not to mention, it sounds like this predates him being Chief Justice.
Because it's a matter of secret state privilege, and it's also connected to the United Nations.
Sir, you have two choices, either to stop asserting this or get the document.
If
I
Mr.
can't,
Ionetti can
just
get the documents, I would appreciate it.
the fact that you just say a thing doesn't mean anything. You have to have the proof.
The only way I can get the documents is for Mr. Ionetti to get it. Otherwise, I can't do it from in jail. If you could give me a PR bond, I would definitely get those documents for you myself.
The problem, sir, is you just keep committing new or alleged to have just keep committing new crimes.
Allegedly, but I assure you I'm innocent.
So were you able to obtain any documents, Mr. Ionetti?
Not without, I'd have to get funding from the court to
Oh,
obtain.
got it.
And they said it was an archive. The person that I spoke to said it was an archive, and they were willing to go down and get it and make copies, but they said it's $1 a page.
Is it all or nothing? I mean, that you have to get the whole file or none of the file?
Because I don't know the answer to that question. I can try and see if there was a judgment out of that case that I can just get the judgment, but I don't know specifically what I'm looking for because Mr. Evans told me that what I'm looking for is under seal that only Chief Justice Roberts can get me. And I don't think I need to contact Chief Justice Roberts and ask him to give me the document out of that case.
If I'm lying about Chief Justice Roberts, trust me, these state charges, these petty charges are the least of my concern.
I can write a letter to Chief Justice Roberts, but I don't know what that will accomplish.
Can they tell you if anything is sealed?
I asked, and they said there's nothing sealed in that case.
Okay, well, that says something right there.
But Mr. Evans indicated, and is this okay that I say this, Mr. Evans, that what you want is only what Chief Justice Roberts can release?
Correct. It's a matter of secret state privilege. So you're gonna be able to see, but you're not gonna be able to see, so to speak, because the Supreme Court of the United States of America has it set up that way purposely for these type of purposes.
I'm not aware of them having this procedure.
Right, because if you're not familiar with the rights of a sovereign state and a sovereign tribe, you wouldn't know the ins and outs. But it's a matter of life and death that I know this and that I have the knowledge of what I'm talking about.
Mr. Ionetti, I would authorize funds for you to obtain the judgment. I'll give you up to $100. Okay. I am ordering a 1077 evaluation. I have concerns about Mr. Evans' ability to proceed. So this is on the court's initiative.
Is this gonna delay my trial?
I'm leaving the trial date set where it is. Ms. Chenwiller, I'm assuming that there's no immunity agreement between you and Mr. Evans.
I would like to put one in place if possible, an immunity agreement based on the right, on the fact
Sir,
that
so this would be with regard to your conversation with the evaluator. It's not immunity from this case.
okay, so I have to speak with the evaluator?
To get this
Correct.
done.
Pardon?
City would not object to that to get this done.
Can I make an objection to that?
To what?
The order for the 1077?
Yes, and
evaluation.
you have objected. I'm ordering it anyway.
Can I appeal to the Supreme Court or to the appellate courts?
I can't give you legal advice. I mean, I can give you.
Mr. Ionetti, I would like to appeal that decision that the judge made to the Supreme Court of the state of Washington directly due to it being a matter connected to national and homeland security.
I'll come and talk to you about how you file an appeal. Your Honor, and this is, yes, okay, the court checked the right box for this. So the city's indicated that they don't have an objection to an immunity agreement. And so this sounds like Mr.
And I also would like to have a notice to remove this case due to bias and prejudice to the federal courts, please.
That's not a basis to remove a case to the Supreme Court, I mean, to the federal court.
Bias and prejudice is not a reason?
No,
And violation of my constitutional rights as well, and civil rights. I think that would be a very valid reason, but I I'll let you go with your decision. If you failed, if you
It's
are,
up to you, sir, if you can file to remove it, and you
Yes,
do you.
Mr. Ionetti, can you please file a motion, a notice to remove to the federal courts based on violation of constitutional and civil rights, please?
I will come talk to you about how you can do that.
Would you like Mr. Ionati there at the evaluation?
No,
Okay.
unless are we gonna be talking about anything legal?
I have no idea, sir. That's between you and the evaluator.
Yeah, if we're talking about anything legal, I want him there as standby counsel to explain my legal rights, far as my legal rights constitutionally and state-wise. But, if it's just questions regarding my competency, I can handle that on my own. But once it goes into, my rights and whatnot, I definitely need counsel available.
Mr. Ionati, based on your experience, do they discuss rights other than informing defendants of their rights?
My experience is that they tell them that that they're going to write a report, and anything that they say to them is going to be included in the report. They ask them about their understanding of what the charges are and what their understanding of what the court's role in the case is. I don't believe they ask the person to give up any rights or do anything of that nature typically.
If they're just asking me if I understand my rights and if I understand the charges, I completely understand that. I could tell you now, I'm being charged with trespassing, and the definition of trespassing, according to the state, is to enter a building, without permission, knowingly, unknowingly knowingly or
That's okay. I believe that you know that what
If the
elements of the
court
charge.
wants to check the box that he wants us present, then that's fine, and they can notify us, and we'll make an effort to be there or schedule with them when it works out.
No, I don't want them there if it doesn't have it, if the questions aren't pertaining to anything legally. I don't want them there. If it's just questions regarding my sanity, I can do that myself.
Okay,
That's my understanding. The only legal questions really they ask is your understanding of the judicial system.
Well, yeah, I can do that myself.
okay. All right, I'm setting a return date for that of June 14th. I'm not striking the trial date at this time. We'll leave it where it is. So we will see you back here for the readiness hearing. Will be your next hearing, sir.
Okay, and the subpoenas, you said you won't be able to honor these,
It's not a matter of honoring. I don't have the power. My power and Mr. Ionati's power ends at the borders of the state of Washington.
Okay, would that be grounds for having this case removed to the federal courts, being that I have witnesses that will be able to testify on my behalf that you guys don't have the power to subpoena?
So it's no, the fact that witnesses are out of state is not grounds to transfer a case to federal court. The parties, it's a matter of diversity of the parties. That's my understanding of federal law. This is something you should discuss with a lawyer, though. I am not I don't do federal practice, so I'm not, I haven't really thought about this since law school, to be honest, but you can have this conversation with Mr. Ionati.
Also, I would like Mr. Ionati to file a motion to suppress any witness statements or
I'll explain to
testimony.
you how to do that.
Okay, but I'm putting it on record that I want the witness statements suppressed or any testimony that they're providing, because they have incentive via the case that I provided you, possibly, to provide false testimony.
So a case that no one knows what's in it, and that's going to bias your witnesses?
Based on the fact that they could be under non-disclosure agreements, which is kind of like what's going on with that case.
Okay.
That case is a matter of secret state privilege. So of course you're not going to be able to just look at it and see exactly what's going on with it, other than taking my word and contacting the Chief Justice Roberts, who will send superseding orders, as I stated in the letter.
I suggest that you write to Chief Justice Roberts then for assistance, because I don't know.
Once I go through the appellate process, I assure you I will, and I can assure you he's paying attention to what's going on.
Okay, all right. Well, we will see you back here then for readiness. Thank you, sir. Bail remains as previously set. Do we need a commitment order, Madam Clerk, or can the? Oh, you've got one in here, or I put one in here, I guess. Okay.
And I don't mean to add to any difficulty, but the city wants to be sure that it is prepared and clear on its obligations. So the court is leaving the jury trials previously set. So we do have readiness on, was that June 12th we had set up
Yeah,
for?
it does come 2 days before. We'll likely have the evaluation.
Great. So the city will go through its normal witness list and subpoena process, just so the defendant's aware. He had mentioned or named Lance Little, Director of Operations at CTEC International Report, as a potential defense witness at the last hearing. We're not going to subpoena
And I
that
also,
individual. Again, if he's a defense witness, that would be the obligation of the defendant, just to be clear on that.
I would also like to subpoena the Kitsap Airporter CEO that of the airporter that goes to the airport. Kitsap Airporter Charter Bus is the name of the company. Kitsap Airport. I would like to subpoena that guy as well.
Again, just to be clear, that's defendant's responsibility, and he would need to provide that information to the city as well.
Mr. Ionetti, are you taking notes?
I will come to you. You represent yourself, Mr. Evans, so I'll come to you and explain how you can get that done.
My hands are tied inside the jail.
I know.
I don't even have enough paper.
So,
to
Mr.
do
Evans, I'm going to
what-
come talk to you and give you the paperwork so that it can get done. And then once it's prepared, I can file it for you.
And so just to be clear, even though we are leaving the jury trial on because the court entered the order for the competency evaluation, per court rule, the speedy trial is told. Thank you. And the city was ordered to provide discovery to the defendant. What, Mr. Ionati, do you know the best way to get to that to him in SCORE?
Is there, I think if there is, I mean, is there other stuff other than paper copies? Is there anything else other than documents?
It's a
I
potential
don't-
I can make a
911
copy of
recording.
everything.
There's a potential 911 recording. There's custodial statements I read that's involved as well. I don't have any of that. And I would like a full discovery, everything that the city or state's gonna use in the trial.
And you
against-
have a right to that, sir.
I haven't gotten it yet.
Mr. Miller?
I can print everything off that's printable. As far as if there's anything electronic is the only issue. I don't know what, I can go there and play it for him.
And also, what case is it that we're taking a trial on the 24th? Because I didn't get that information. That information wasn't specified either as well. So
I
what
know,
case?
and I said this, sir, at the time, we'll set all of them for the same day. And then based on witness availability and based on what makes sense, we'll just figure out which one goes first that day.
Thank you for clearing that up, Your Honor.
And I said, I'm just repeating myself, sir.
It never was made clear to me when it was officially done. So I thank you for clearing that up for me, as well as officially explaining to me what an affirmative defense was that Mr. Ionati couldn't legibly or competently explain to me, which is why I wanted him fired.
Mr. Ionati, I may need to email you then on when I review the cases further, if there's electronic discovery that needs to be sent to the defendant.
Okay.
All right, thank you, sir. We'll see you back here on the 12th.
Thank you.